Yes, ma'am. Good morning.
Good morning. If it please the court, my name is Lisa Johnson, and along with my colleague Stephen Ernstoff, I represent the appellants who were the plaintiffs below, Kleber Coleta dos Santos, individually and as father and next friend of the minor plaintiff Brian Coleta and his wife Kayla Coleta. I know your honors are familiar with the record, but if I could just state a few salient facts which I think are important to the analysis. Plaintiff Kleber dos Santos, was injured in August, catastrophically injured in August of 2005 when he was using a trampoline pool set up by the defendants, Jose and Maria Coleta, in their backyard. At trial, importantly, Jose Coleta testified that it was his idea to set up the trampoline next to the pool. He said that he had seen it done at other houses and that he did it specifically so that people visiting his house could jump on the trampoline and access the pool.
Was there any testimony at trial about, I believe there was testimony that was both children and adults, correct, jumping in?
That's correct, Your Honor.
But what about the distinction between jumping in, I take it, feet first, and diving or flipping? Was there evidence that before this day there had been people doing that?
There was testimony not only that people had been jumping and, feet first kind of, or for lack of a better, bottom first into the pool, but also testimony that Washington Barelo, who actually lived in the same side of the duplex as the Dos Santos family, and was a friend of Kleber, obviously, Dos Santos, had been flipping into the pool. There was testimony that that had occurred as well.
Can you just sort of, I know that the pool was 2 feet deep in water and that the trampoline was 3 feet off the ground. How big, in terms of circumference, were each of these things? I mean, what were the dimensions of the trampoline and what were the dimensions of the pool?
My recollection, Your Honor, is that the trampoline was approximately 12 feet across. And that the pool was about that same size. I don't remember the exact dimensions, but they were similar in size. And when they were placed, the record contains photos of when they were placed next to each other. You saw the trampoline, which was large and a little higher than the pool, and then the pool, which again, it wasn't a little kiddie pool like the hard plastic pools that we think about for toddlers to go in, but in fact it had quite a great deal of water in it, and it was inflatable, and again I think it was about 12 or 14 feet in diameter.
Can I ask you this? Let's assume there was no pool and this was just a trampoline and your client wanted to do a flip and land on his rear end in the grass, a video for funniest home videos, whatever purpose. Would you say the jury instruction that you sought should be given in those circumstances as well?
Excuse me. I don't know that we would have asked for that instruction in those circumstances. I think that the emphasis in our case was on the defendant's conduct, and in that case, by setting up the trampoline directly beside the pool with the express intent that people would in fact jump off of that trampoline, wouldn't stay on it, but would use it to access the pool.
All right, so the trampoline alone wouldn't necessarily justify this instruction that you're
Not
asking.
necessarily.
All right, let's just take the pool alone. Let's assume that the defendant here had built a little wood platform around the pool so one could sit and stick their feet in and wouldn't have to go into the pool physically, and your client tried to do a flip off of that into the pool. Would you say this instruction would be required?
Again, the facts of our case are certainly unique, and we've said that all along.
So probably not under the O'Sullivan case, is that right? Probably not.
I think probably not. In this case, by putting that trampoline, which it was evident to everyone that people were going to jump on it and jump high and jump from it and somehow use it to get access to that pool. That's what changes the character of the defendant's conduct here and the foreseeability, which is what I believe these cases are about. foreseeability on the part of the defendants that someone would in fact be injured jumping on that trampoline and accessing the
You're
pool.
not really
Yes, Judge.
challenging the fact that there was no duty to warn because it was open and obvious.
Well, I'm saying there was a duty to warn, because even though the danger presented by that pool trampoline
Is it a
setup...
duty to warn or a duty to repair?
I'm sorry, I apologize.
A duty to remedy.
Duty to remedy, I'm sorry, that's the emphasis of our argument. You're absolutely right, I misspoke.
No duty to warn, but you're saying there's still a duty of care in the form of a duty to remedy.
Exactly.
And that comes from this exception when there's, because the O'Sullivan case, didn't it say that the duty to warn ordinarily, I'm sorry, when there's open and obvious danger and there's no duty to warn, basically negates the duty of care.
Exactly.
And in subsequent cases, it's been made clear that there may be a residual duty of care, even if there's no duty to warn, under the restatement 343.
Section 343A.
But that's an
exactly.
exception, right? And it has to be only in some circumstances, right?
Exactly. In circumstances where it's foreseeable to the defendants, notwithstanding the open and obvious...
or that the possessor should anticipate. Is that the same thing? Is that the same thing as foreseeability in connection with proximate cause?
Well, it's the same as foreseeability in the context of the whether or not there's a duty of care. Proximate cause, again, would be another question. If the jury determined under our scenario, our proposed instructions and special questions, if the jury had determined that it was foreseeable to the Coletas that someone would be injured as a result of using that setup that
In
they
any way,
created.
using it in any way, that they could be injured in any way.
No, Your Honor. In using that pool to access, using the trampoline to access the pool, which is the express purpose that they put it there.
But there are safe ways to access the pool from the trampoline, are there not? Or are you saying there are no safe ways to use this trampoline to access the pool?
You could certainly climb from the trampoline into the pool.
Or how about jumping feet first?
I think that jumping feet first would, if you were actually using the trampoline in the way it's intended to be used, which is bouncing up and down to get extra height, and then jumping feet first or bottom first into a 2-foot pool, in my view, that would be dangerous.
But not nearly as dangerous as trying to do that with a front flip
Not nearly as
in
dangerous.
2 feet of water.
Well, I don't know. It would be dangerous in either way. And I think that the case law is clear that the defendants didn't have to foresee the precise manner in which someone would be hurt, just that they could be hurt.
But even, you may not even need to, if I understand your, which I don't have any, I haven't looked at it, but if you're correct about the facts, you have a case here where it's not just what theoretically might happen. They knew it was being used in exactly this manner.
They knew it, and they testified that they knew it was dangerous to use it that way.
I'm sorry, you said they knew it was being, people were doing bat flips off of this?
No, they knew that people were jumping on the trampoline and entering the pool. There was testimony both ways. Did they know there were actual flips going on? Kleber Coleta dos Santos testified that they did know. I don't believe there's testimony in the record as to whether, from the defendants, whether they specifically knew of the type of maneuvers that people were using. But they did both testify that they saw people jumping on the trampoline and into the pool, and they both testified that they knew that was dangerous. And they testified that they set up the trampoline directly beside the pool so that people could engage in that activity.
So if there's a duty to remedy as part of the duty of care, in this instance it means you have to dismantle the entire thing, right? I mean, you cannot have the trampoline next to the pool. There's no other way to remedy this situation, is there?
In this specific case, I think the duty to remedy would, either be to put up one of those guards around the trampoline or to move
So
them.
that they can't be used in tandem.
Correct.
You would have to disable that.
Correct.
The tandem use.
Somehow.
Yeah. You could
Right.
use both of them, but they
Could
just
use
can't
both
be right
of them
together.
separately, but not
in
to
tandem.
set them up in such a way that it would invite people to use them together. Mm-hmm. It's a higher level of danger in our view. And again, created by the defendants, specifically so that visitors could
Well,
use
does that
it.
really matter? that it was created by them? I mean, that could just be on their property, right? And the same, it would seem to me you would still have to be making the same argument about their duty.
You'd still have an
of care.
obligation, absolutely. I'm simply suggesting.
If they just bought the house and it was there, and then the same thing happened, it's the maintaining of it rather than the creating of it, right?
It was, and except that I think the fact that they created it for that purpose does go directly to the issue of foreseeability. And as Justice Botsford pointed out, in our case, there's testimony that, in fact, the Coletas did foresee that someone could be hurt jumping on that trampoline and into the pool. So it's not even a question of whether they foresaw that that could happen. We did request that special question, but given the testimony, undisputed testimony, it would seem that the answer to that question would have been yes.
So in your view, this should have proceeded where the rubber would meet the road in terms of comparative negligence, I take it?
Absolutely, and we always, in our special questions and in our instructions, we requested an instruction on Kleber's potential comparative negligence, and we always understood that that could be a significant issue for him.
It could be dispositive.
Absolutely, although it wouldn't have been dispositive for his wife and his child who had consortium claims. And we were willing to take that risk, just allow the jury to evaluate the defendant's conduct, evaluate Mr. Dos Santos' conduct, and then allocate responsibility, as they saw fit. But the jury was never able to do that.
Now, your brother says that the instruction should not be given, but that it should not be given because no rational person would have done what your client did. And he takes language from O'Sullivan and Shaw to support that. Why is that not a fair reading of O'Sullivan versus Shaw?
Well, in the open and obvious danger rule doesn't take into account what a rational person, the conduct of the plaintiff. That's the assumption of the risk. If you look at the conduct of the plaintiff and you say, no rational person would have done that, then if the assumption of the risk were still in place, that potentially would bar his claim. In this case, we focus on the knowledge or the mental state of the defendants. And in this case, they testified that they foresaw what happened, not the specific manner or severity of the injury, but they testified that they did foresee that it was dangerous, or they foresaw that someone would use that trampoline, and in fact, that's why they put it there, to jump or access the pool, and that they knew that was dangerous. So in many cases, I would agree with you. At the end of the day, it would be unreasonable to hold a defendant to the knowledge that someone might act in that fashion. But in this case, they testified that they knew. So there's really no question.
You're saying that there was testimony that they knew that people not only jumped into the pool, but did things like front flips into the pool?
There was testimony as to that, yes.
That they knew that. They had
That
observed
they knew
that.
it. The testimony came.
No, you said before there wasn't testimony that they knew that. They knew people were jumping in.
It wasn't their testimony, Your Honor. It was testimony from the plaintiff who testified that he was present and the defendants were present when other people were flipping into the pool. That's what there was evidence. It just didn't come from the defendants on that particular issue.
So I know that, of course, the O'Sullivan rule on open and obvious tests a hypothetical person's, what a hypothetical reasonably intelligent person would do. And in O'Sullivan, it seems pretty clear that the court thought that what the plaintiff there did was not the action of it was foolhardy. And that the fact that other people think that they could do the same foolhardy thing in a safe way is irrelevant in determining that. Okay, so that goes to the open and obvious. But in determining whether you should anticipate whether, for the purposes of this exception, in determining whether or not there's still a duty of care to remedy.
Yes.
Do you have to? What is it that is it what the reasonable owner would anticipate, or is it what an owner would anticipate from reasonable people? You know, I mean, you're going to have outliers who do all kinds of bizarre things. Somebody could go, you know, make a use of something that is, you know, way at the extremity. Is that something that an owner has to anticipate?
I think that where an owner takes affirmative action to create a condition, we view it as a dangerous condition on his premises, with the intention that somebody or that people are going to use that condition in a particular way, and they do that, I think they must be held to have anticipated that someone would be harmed. And I know that's not exactly the question that you asked, but in this case, these defendants did anticipate that someone could be hurt jumping on that trampoline and accessing the pool. And for that reason, we believe that the question of foreseeability should have gone to the jury.
All right, we'll have to leave it there, counsel.
Thank you, Your Honor.
Please the court, Your Honor. My name is Mark Mankin. I represent the defendants Jose and Maria Coleta. I know that your honors are familiar with the facts. The opinion of the appeals court was quite good in summarizing the facts of the case. One thing they didn't put in here was that Mr. Dos Santos had stood in this pool a couple of times prior, 1 or 2 times prior, in the 2 feet of water, and he had stood next to this pool a number of times when his son was in the pool, so he was quite familiar with the level of the water in the pool.
In connection with open and obvious and landowner's duty, well, just take open and obvious, at least as the plaintiff's conduct or knowledge isn't what we look at. We're focused on the defendant, aren't we?
Yes, it does. Whether there's a duty to anticipate that the plaintiff will engage in what was called foolhardy behavior in the first case, in O'Sullivan against Shaw. And I think the holding was that there is no duty of the defendant to anticipate that a plaintiff would dive into shallow water, being that that is a rather foolhardy thing to do. But I would say this case is more compelling than O'Sullivan against Shaw. At least in this case, the pool was entirely above ground, again, and he had stood in it, so it was visible to someone who was contemplating doing a dive. In this case, there was 2 feet of water in the inflatable pool as opposed to 4 feet of water in the O'Sullivan and Shaw case. So,
but what do you say about the restatement of torts, which has been, reflected most recently in Papadopoulos?
I would say I don't believe the restatement 343A really belongs as an issue on appeal. It was never pleaded. It was never argued. It was never brought to the trial judge's attention. It's showing up here in the first instance on appeal.
But wasn't that the substance of what the plaintiffs were asking for?
I don't think that the plaintiff's request really tracked 343A very well either. That was some discussion that was taken out of Soderberg, but the 343A is a provision of non-liability, and it was presented in this request for an instruction not particularly well. It was certainly incompletely, and I think the trial judge would be on solid ground if he had never been notified that 343A was going to be an issue in the case, never in the charge conference, nowhere in the transcript does the word 343A come up.
Very sorry. I've gone off. Oh, my God. Sorry. This is exactly what we kick people out of court for, right?
So I think it was an incorrect way of
I'm sorry, I can't.
of trying to get 343A in front of the jury.
I just take this out.
Hold on just one moment. I'm going to ask the clerk to stop the clock. We don't want to penalize the attorney. Bear with us, counsel.
Thank you. Thank you, Your Honor. I will do that.
I apologize to my colleagues and to everyone in the courtroom. I'm very sorry about that. I'm technologically challenged.
Anyway, I hope I answered your question, Your Honor.
Yeah, if I can, how far would you carry your idea? Let's assume that there was a balcony, a second-story balcony, where there was no barrier because it had been damaged and had been taken down, and the person puts a sign on the window which says, "Warning, there's no railing on the balcony." But yet the person knows that people are going out on the balcony and maybe even drinking on the balcony. Is the warning sufficient? Is the danger is open and obvious, and even there's a warning? So are you saying that there would be no liability there for the owner of the apartment if somebody were indeed, during the course of a party, to fall off?
Well, in the course of a party where drinking was going, that would be an entirely different scenario, but
Why is that?
well, someone's ability to comprehend what was going would certainly be impaired by the alcohol. But if I may, Your Honor, if you change that hypothetical a little bit to say a plaintiff who knew there was no barrier there wanted to make a home movie, as the plaintiff was in this, in our scenario, and intentionally did a flip off of the second floor balcony and got a bad injury, that's a different consideration, I would say. This dive.
Okay, but this is a bit different in that the trampoline is designed to be jumped upon and is designed to gain height, and it was next to a pool, and you knew that people were jumping high and landing in a short pool. Why is that not warning enough to say
There was no testimony that people were jumping high and landing in the pool.
Can't you infer that from, I mean, what's a trampoline for?
Well, the plaintiff said that he understood these things could be used separately from each other, and he saw them being used separately from each other. Sometimes the trampoline was in different parts of the yard, for that matter.
But are you saying that the trampoline, the fact that it does not pose a special danger by increasing the height that a person is going to be jumping into a pool from as opposed to jumping from the ground? I mean, isn't that by itself a distinguishing factor from O'Sullivan versus Shaw?
Slightly, but the point is the diving, not the jumping, the diving, instead of what you're diving from, because in O'Sullivan, there was no need for a trampoline to get a broken neck either. Mr. O'Sullivan did that without the benefit of a trampoline. So I would argue to Your Honor, it's the point of the dive, not what you're diving from.
Is there any safe way to use a trampoline of that size next to a pool of that size?
Well, people were doing it, Your Honor.
No, well, the fact that they did it in O'Sullivan, too, many people did racers' dives in the shallow end of the pool quite safely, but that didn't make it a safe activity to do. The question I'm asking is, there were ways, I guess, of being able to use that pool safely.
Certainly.
I meant in the O'Sullivan case, because you could have just slid in and so forth. Was there any way, though, you could use the trampoline in a non-dangerous fashion? I mean, if there was the testimony that the owners apparently gave that they knew it was dangerous, they didn't want their children jumping from the trampoline into the water. So what was the safe way to use this that was non-dangerous?
Well, just stepping off of the rim of the trampoline, which we saw someone doing in a video here, involved a drop of 12 inches from the rim of the trampoline at 3 feet into the surface of the water at 2 feet.
Well, but suppose you jump on it, so you're going to go more than 3 feet, right? You're going to go 4 feet, 5 feet, 6 feet into 2 feet of water. Even if you were just jumping up and landing on your feet.
If you elected to do that, there was no testimony that that was going on.
That people were jumping, bouncing, and then
No, correct.
there was no testimony to that effect. That people are using a trampoline basically as the equivalent of a platform just to slide into the pool?
It was never really established, other than that one picture we saw of the gentleman who Attorney Johnson mentioned. There was a photo of him stepping off of the trampoline into the pool. But there was not extensive testimony as to what jumping meant during the trial. I don't know if stepping off would be jumping or not.
Attorney Johnson informed us that there was testimony from the defendants themselves that they knew that the trampoline that they had set up in front of the pool was dangerous, and that they knew people were using it to gain access to the pool. What are we to make of that?
Well, I would say there's a certain danger in any playground equipment. They were not saying it was hyper dangerous or anything like that. I mean, using a swing set or just about anything entails some danger. They didn't say they knew people would dive into the pool and add that extra level of danger that goes way beyond stepping off of the rim of the trampoline, Your Honor.
So they did not testify that they had seen people going from the trampoline into the pool?
They did testify to that, but
They did or did not?
they did. But there's no testimony that they ever saw anyone diving into the pool.
Well, how did they get from the trampoline into the pool? Did they jump on the trampoline and project themselves into the pool?
That was never established at trial, Your Honor, other than that photo that I
I mean, isn't the reasonable inference that it was a jump and then, as counsel said, either landing foot first or bottom first in the pool?
The jumping aspect was never developed by either side. So whether that meant stepping off, as we saw in the photo,
That's not jumping.
that may be a word that someone, I mean, you could stand on it and jump at the same time. It's stepping off, but it can be a jump at the same time. All I can tell you is that testimony was not developed at trial. So I would argue to Your Honors that O'Sullivan was good law in the year 2000 when it was decided. I submit to you it's good law today.
But isn't it, it's a warning case, isn't it?
No, I disagree with that, Your Honor. There is wording in the body of O'Sullivan that goes beyond warning. Although the conclusion does say warning, but at page 204, the court says, moreover, it is well established in our law of negligence that a landowner's duty to protect lawful visitors against dangerous conditions on his property ordinarily does not extend to dangers that would be obvious to persons of average intelligence. So I think they've gone beyond, in the body of the opinion at least.
And then what do you say about Papadopoulos?
I would say both Papadopoulos and Soderberg essentially address themselves to snow and ice. And the activity of walking on ice is something that is ubiquitous in New England, and we all face it, and we all have experience doing it. That, I would say, is different in kind than intentionally diving into 2 feet of water in a pool. So I agree that Papadopoulos and Soderberg certainly changed the law on snow and ice, and perhaps something beyond that. But I didn't read those as purporting to either overturn O'Sullivan or affecting the laws that exists on intentional diving into shallow water. So that would be my response to you, Your Honor.
And I take it on Papadopoulos, you would say, well, people are going to these parking lots and to these stores to shop. So the owner can reasonably anticipate that they're going to try to get into the stores.
Of course, Your Honor, a legitimate activity of daily living would be shopping or something like that. It's far afield from an intentional dive into 2 feet of water. So I think there is a distinction between those snow and ice cases. And
Are you suggesting we shouldn't adopt 343A, or have we adopted 343A, the restatement?
certainly not in a shallow diving case, and I would say it should not be adopted, Your Honor. I would argue that the reasoning in O'Sullivan should be sustained.
Well, if there were evidence here that the defendants knew that the trampoline was being used as a springboard into the pool, and in fact put it in that position for that purpose, and they were encouraging people to have a good time and come out and party and jump from the trampoline into the pool, shouldn't 343A be part of the court's analysis or the jury's analysis in those circumstances?
Your Honor, some peripheral witness said he was present when the defendants were present when somebody did a flip. Now, how strong that is, I don't know.
Yeah, but my question is, shouldn't 343A be a viable tool to analyze the facts and those kinds of facts?
Other than, or beyond what I said before, that it's, I don't believe 343A belongs here. The appeals court, at least, for what it's worth, said that it's not reasonably foreseeable that someone is going to dive into 2 feet of water. And I think that is a good statement of the law.
Now, in O'Sullivan, what would be the remedy that the pool owner could have invoked in order to prevent this?
Well, that's a very good question, and it raises the issue, if the standard is changed in this case, you would think that all pool owners, whether they have in-ground pools, kiddie pools, raised pools above ground, would have to put barriers, I would say, at the water line around the pool. Otherwise, they would get sued for not preventing someone from diving into the pool. So it would, I would say, it would be rather onerous.
Well, counsel, your time is up.
I thank you very much, Your Honor.
Yes, sir.